First of all, I would like to thank the organizers and admin J. Safra, Center for Ethics, for allowing me to participate in this stimulating discussion. Force feeding and enforced medical treatment more broadly is a very delicate topic that has gained wide visibility in recent years, mainly due to its correlation to a revival of hunger strikes as a political tool in a number of contexts around the globe, including Israel, of course. Rather than trying to solve the problem in 15 minutes, I would like to use the time given me to first present you with a brief historical development of the main concepts used to legitimize or not force feeding, autonomy and competence. Second, I will mention two cases in which those two concepts have been applied in a rather controversial fashion. I will not suggest a specific solution, but hopefully those contrasting examples will provide us with interesting inputs for furthering the debate on the topic discussed here today. In the current Anglo-American legal system, the notion of respect for patients' autonomy has increasingly gained more relevance vis-à-vis a paternalistic approach that was dominant in the patient-doctor relationship. Paternalism had assumed that physicians were to be allowed to interfere with a person's freedom of action, a person's autonomy, on the grounds that it is for the good of the person. In the words of Tom Beauchamp and James Childress in their influential book, Principles of Biomedical Ethics, the autonomous person determines his or her course of action in accordance with a plan chosen by himself or herself. Such a person deliberates about and chooses plans and is capable of acting on the basis of such deliberations, just as a truly independent government is capable of controlling its territories and policies. The growing number of debated cases of refusal of medical treatment and its denial on the grounds of impermissibility in the name of the patient's best interest has underlined the need for our attention to be refocused on the actual disappearance of paternalism from bioethical debates. The crucial switch in power relations is characterized by the acknowledgement that under satisfactory conditions of competence, the patient is the best judge of providing or rejecting informed consent over a medical procedure concerning her. Prior to this conception of patients knows best, there existed a dogmatic view of doctors as the best judges by definition. After all, what can the patient be expected to understand about the procedure that she may or may not decide to undergo? Eventually, it was realized that doctors are as imperfect as any other professionals, and though generally more informed than their patients, doctors can fail just as every other human being engaging in any practical activity can. The a priori justification of valuing the nobility of having chosen a profession where an irreversible mistake can be noticed was no longer satisfactory. The more this knowledge of fallibility spread in society, the less people were willing to trust doctors, resulting in a need, gradually expanded, for an increase in the patient's decisional power, or, in more technical terms, in greater respect for her autonomy. Despite the fact that, as a result of such developments in the West, in current bioethical debates, there exists a tendency to assess autonomy or competence as the function we can or cannot have within a given system, this respect for the notion does not seem to be applied consistently. My suggestion is that we must abandon the mental state that puts a barrier between the sphere of bioethics and the broader political scheme within which certain interpretations can be questioned. We need to examine the inconsistent role granted to autonomy in the two spheres of justice, political and bioethical, in Western society and address its limits. The two cases considered, related by the use of autonomy as their basic principle of justification and their political contexts, will help me highlight the inconsistency I refer to. The first case I want to present you is the Singleton case. because although not a direct case of force feeding, it represents a uniquely good example of the interconnection between competence and autonomy within the spheres of politics, law, and ethics. In 1979, Charles Laverne Singleton killed a grocery clerk in Arkansas and was sentenced to death that same year. Once on death row, he began taking psychotropic medications to alleviate anxiety and depression. However, in 1987, his mental health deteriorated further to the extent that he claimed that his victim was still alive and he himself was possessed by demons. Singleton was diagnosed as schizophrenic and prescribed antipsychotic medication. During the following years, he oscillated between agreeing and refusing to take the medication. As a result, when he spontaneously refused to take it, it was forced on him. When he went off the medication, the paranoid and delusional behaviors returned. By 1997, antipsychotic medication had become so necessary that the prison placed Singleton under an involuntary drugging regime, subject to annual review. Under this regime, Singleton's mental health improved to the extent that the state of Arkansas authorities considered him eligible for execution, scheduling it for March 2000. Singleton then filed a petition for habeas corpus, contending that he was only competent because of the medication he was being forced to take, and that it was unconstitutional to use enforced medication to raise his competence, such as to become eligible for execution. By the way, habeas corpus is a legal action of English origin which has been an historically important instrument to ensure protection of individual freedom against arbitrary state action, and which can be used to seek relief of unlawful detention. The Eighth Circuit Court of Appeals was called upon to decide whether the state could execute someone forcibly medicated in order to meet the competence requirements for proceeding with the execution. I have discussed, as elsewhere, the various layers of controversy of this case, but here I think that the most relevant aspect to consider is that of the tension between the different degrees of autonomy allowed to Singleton. He was competent enough to be executed, but not to refuse medical treatment. Eventually, he agreed to be medicated, and in January 2004, he was executed. Nonetheless, doubts remain over the moral justifications for authorities for enforcing medical treatment upon him, knowing that this would have resulted in his death. This care to medicate is instead surprisingly absent in the second case I want to consider. Despite sharing some general aspects common to most hunger strikes cases, I think that this case that took place in my country of origin also provides some specific insights of the multi-layer complexity of the issues at stake. Samin Barka Bengarci was a Tunisian prisoner held in prison in Pavia, Italy. He was charged with rape. He went on a hunger strike as a way of insisting of his innocence. His autonomy was so deeply respected that no one decided to intervene forcibly, even when his health was clearly deteriorating to a dangerous extent. After Bengarci's death, the director of the prison claimed that to deprive someone already in prison of their self-determination power is cruel. It seems obvious that such a respectful view of prisoners' autonomy is, fortunately, not the most common approach that prisons have towards their inmates. Otherwise, we might feel ethically entitled not to intervene if we see a prisoner hanging himself without this producing any sense of guilt in us. Bengarci was assessed as being competent. His decision to refuse food and hydration was fatally respected by the prison authorities and, despite various levels of legal challenge, endorsed by the Italian Ministry of Justice. He died on the 5th of September 2009. Bengarci was allowed to use his own autonomy to kill himself, leading to a fierce defense of the principle of autonomy, completely unprecedented in the Italian context. This lack of precedent in itself provokes many questions as to why tacit consent was given to Bengarci in this particular case of hunger strike. In an article published a few years ago, I focus on establishing the extent to which the social preconditions of an individual prior to a certain criminal action can change the value assigned to the life of a given human being in a particular Italian society. Had it not been a Muslim foreigner charged with rape, he might have been disarmed. Obviously, each of the cases has a specific political charge that cannot be discussed here, but they share insights on the key questions surrounding force-feeding. Are we allowed to intervene to preserve the sanctity of life beyond any other principle, namely that of autonomy? In other words, should the authorities put aside the evaluation of competence in prisoners in favor of a focus only on the gravity of their medical condition? In relation to those questions, some final considerations should be made. A hunger striker has been defined by the World Medical Association as a mentally competent person who has indicated that he has decided to refuse to take food and/or fluids for a significant interval. However, this definition, who determines what significant means, overlooks the fact that even where initially competent, prisoners partaking in hunger strikes suffer from a multiplicity of mental disturbances related to their imprisonment. A unique, single-bodied notion of competence has been questioned by many authors. Among these, Eike and Kluge affirms that there are as many as 3 different versions of competence: cognitive, emotional, and valuational. While the former would overlap with the standards of mental capacity, based on rationality, the latter two also take into account the value of the individual's dispositions and wishes. In most hunger strike cases, for example, the aim is to protest, not to die. Since hunger strikers are left with very few options for action, to die or suffer from what they perceive to be a gross injustice, in some sense, then, we could affirm that both emotional and valuational competence are absent in hunger strike. These latter definitions of competence are similar to what Ronald Dworkin famously defined as the individual edge of life, bios. We could then claim that those competences should be preserved so to defend the real self of the person. In this semi-paternalistic scenario, however, it would appear as if, on the one hand, force-feeding might be less morally repugnant than initially thought in certain cases of hunger strike. On the other hand, singleton force medication appears to be morally condemnable because even if the cognitive version of competence might have been assessed to be absent, the emotional and valuational versions of competence were present and contrary to the medication. Thank you.